Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Yeah, we do have another update. I'm seeing the comments already. I do have another update on the Taylor Swift situation and the Justin Baldoni versus Blake Lively case. Whoa, voice crack. We have Bryan Freedman, the attorney for Justin Baldoni, who put out the Taylor Swift allegations that, Blake Lively had threatened Taylor Swift and tried to get her to delete their text messages. He's come out with a new letter. In that letter, he attaches a signed affidavit with, his statements about what happened with Taylor Swift and what the source told him. Yesterday, Mike Gottlieb was the attorney accused of talking to Taylor Swift's attorney on Blake Lively's behalf, trying to make certain demands that they, put out a statement of support. But Ezra Hudson, another attorney for Blake Lively, filed a letter basically saying this is baseless and this is an abusive process and all this kinds of stuff. So I think you guys probably saw that already. If you didn't, then there's a video up that you can go check it out with. But this was his response to that. So we'll go through that together right now, and then I have to get back to my work desk, unfortunately. Give me one sec. Oh, that's the affidavit. Okay, but you can see that he signed it here under penalty of perjury. So, all right. Okay, so here's the letter. Let me move my head. Dear Judge Liman, we write in response to the letter motion to strike filed by plaintiff/consolidated defendant Blake Lively. The motion asked the court to strike my letter of May 14th. The letter was submitted in response to Ms. Lively and consolidated defendant Ryan Reynolds, together the Lively defendants, corrected letter of May 13th, purporting to inform the court of their request to intervene in an action pending before a different federal court relating to the motion of Venable LLP to quash the subpoena served on them by my office. The premise of the motion, The premise of the motion is that I made a deliberate and shameless misrepresentation to the court, and that the facts set forth in the May 14th letter are false and unfounded. That is not so. Attached here too, as Exhibit 1, is an affidavit executed under penalty of perjury, stating the factual basis for the statements set forth in my May 14th letter. Notably, the motion is signed not by Michael Gottlieb, sorry about that, whose conduct gave rise to my office's issuance of a subpoena to Venable, but instead by another attorney from a different firm representing the Lively defendants. The motion also faults the May 14th letter for being filed without evidentiary support of any kind, much less anything under oath. This opposition supplies the sworn affidavit that Lively argues the May 14th letter lacked. Problem solved. Finally, and most notably, the motion claims that the facts set forth in the May 14th letter are unequivocally and demonstrably false. Yet it is unsupported by any sworn declaration to that effect, much less from Mr. Gottlieb. The motion further contends that the May 14th letter was improper because it does not seek any form of relief, is irrelevant to any motion currently pending before the court, and serves no legitimate purpose. I disagree, but all right. Clearly he does too. Of course, the same could be said of the Lively defendant's May 13th letter, which Miss Lively claims to have submitted as a courtesy, and in which she did not ask the court to take any action. In the May 13th letter, the Lively defendants claim that the subpoena served on Venable seeks the Lively defendants' attorney communications, including those of Michael Gottlieb, with no explanation as to how they could be relevant to any party's claims or defenses in this litigation. Given that Ms. Lively herself admits that in the May 13th letter, she did not ask the court to take any action, nor could she, given that motion to quash the subpoena to Venable is pending before a separate court and is outside this court's jurisdiction, it is apparent that the May 13th letter was filed with the court for the purpose of besmirching the Wayfarer parties and their counsel. A response was necessary. The May 13th letter claims in open court that my office issued the subpoena to Venable for an improper purpose rather than in pursuit of relevant documents. Accordingly, we submitted the May 14th letter to correct the record. The motion should be denied. Okay, we'll go over the affidavit now. This is so crazy, man. I don't think we're going to learn anything new here, but it's interesting that he put it in an affidavit. Hang on. Cut the check. I don't think the check is going to cut it, dude. They want, their names cleared. So, okay. I, Bryan J. Freedman, pursuant to 28 U.S.C. Section 1746, hereby declare as follows. I'm a partner of, and then we know this, so I'm going to skim over this part. I submit this affidavit in opposition to the motion to strike, filed on May 14th, 2025 by Blake Lively, regarding my May 14th, 2025 letter, elaborating on the basis for the Wayfarer party's subpoena to Venable LLP. On February 14th, Valentine's Day. That's nice. I received a voicemail from a person very closely linked to Taylor Swift, whom I subsequently called back the same day. Out of respect for the individual in question, I am not identifying them at this time. However, should the court direct me to do so, I will comply with the court's order. During the February 14th phone call, which lasted approximately 1 hour, the speaker told me that they had been informed that J. Douglas Baldridge, counsel for Taylor Swift and a partner at Venable LLP, had received a phone call from Michael Gottlieb, counsel for Blake Lively and Ryan Reynolds, during which Mr. Gottlieb requested, on Miss Lively's behalf, that Taylor Swift make a social media statement in support of Miss Lively, given her absence from the Super Bowl that year, and stated that if Miss Swift failed to do so, Miss Lively would release 10 years of private texts with Miss Swift. Jesus. Who's even keeping 10 years of private text with somebody unless you felt like at one point you were going to use it against them? That's just one way to tell on yourself. The individual also told me that they had been informed that Mr. Baldridge had accused Mr. Gottlieb of extortion and ended the call. 10 years of private text. I mean, she's 35 now? So that'd be everything she said since she was 25 years old to Blake Lively, who is supposedly one of her best friends, and she's the godmother to her children. I mean, what the fuck? That's so crazy. During the same February 14th call, the individual told me that they had been informed that 4 or 5 months earlier, Miss Lively had requested that Miss Swift delete her text messages with Miss Lively. I was connected to this individual through a mutual friend who informed me that the individual wanted to talk. We have had several phone calls since February 14th. On a later call with that same individual, the individual told me that Mr. Baldridge had sent a written communication to Mr. Gottlieb relating to their phone conversation. My office issued a subpoena to Venable LLP for the purpose of seeking the aforementioned written communication. I declare under penalty of perjury, pursuant to 28 U.S.C. Section 1746, that the foregoing is true and correct. Signed by Bryan Freedman. And they had done the motion to quash. Venable had done the motion to quash, but apparently they're now working with Justin Baldoni's counsel in good faith. Whatever that means, I don't know yet. All right. Okay. Well, I guess this isn't going to get any less contentious. Certainly not. But why do texts have to be deleted? I don't know, but that's, colossally boneheaded anyways, because, these the forensic technologies that we use now, they can get deleted texts. No problem. I mean, I'm going to assume that Jennifer Abel probably tried to delete the text where she called her boss a cunt before she returned her company-owned device, but they still got those. And that's a huge speculation on my part. I don't know. I probably would have personally, if I were turning a phone in, delete the text message where I called the person that I'm giving it to a big fat, so. Sworn affidavit means given under oath, yes. Don't you just love how quiet Taylor and her team are? Yeah, so I haven't seen anything from them, and that's pretty telling, given they had given some pretty big statements on Friday, and then there was a lot more going around on Monday. But yeah, even I reached out to her media liaison for comment, and I'm not gonna hear back, but I was like, fuck it, I'll try anyways. So yeah, no, it's I don't think we're gonna get anything anytime soon. How uncomfortable this is for anyone else who's asked to delete evidence and complied. Hugh, maybe. I mean, I have no idea. Hugh and Ryan seem to have a pretty good relationship. Isn't he still hanging around? So, I mean, I don't know if that would be going on there, but Times Magazine's Criminal Titan of the Year, dude. Yeah, okay. Somebody says it'd be great if Travis Kelce was the caller. Yeah, I don't know. I have no idea. So, I love your lightning speed update as they arrive. Yeah, no problem, thanks. I was at my work desk, and I was on a Zoom call with my manager when this popped up, and I was like, oh, shit. All right. Anyways, I got to get back to my desk now. So I'm trying to make sure I didn't miss anything here. Spine must have been surgically removed. Oh, that sounds painful. All right. I got to go back to work, guys. Thanks. You sound so happy. I mean, I am not unhappy. Let's put it that way. Bye.